Hi, this is Mike Haber. Thanks for asking me, how do I get a new public defender? What is a Nelson hearing? Whether it's right or wrong, true or false, many indigent defendants complain about their court-appointed counsel. It could be not returning calls, emails, or texts, not scheduling meetings, not showing up at the jail often enough, not honoring or pursuing the client's wishes, pushing a plea deal, or having an attitude. Whatever it is, such complaints are very commonplace. But standing alone, or even in combination, you're not necessarily entitled to a new or to a different public defender. In fact, in order to get a new public defender appointed, the burden is on you, the client, to prove to your judge that your public defender is ineffective. In 1973, Florida's 4th District Court of Appeals decided a case called Nelson v. State. The legal site is Nelson v. State, 274 Southern 2nd 256, Florida 4th D.C.A. 1973. It set a statewide precedent establishing a procedure that trial courts must follow when a defendant seeks to discharge her or his court-appointed counsel. The Fourth started with the premise that the right of an indigent client to court-appointed counsel includes an implicit right to effective representation, and the Fourth defined effective assistance as making reasonable investigation into the facts of the case and acquainting oneself with the law pertinent to the facts, free of any influence or prejudice which might substantially impair the ability to render independent legal advice to an indigent client. This procedure is now known as a Nelson hearing, and it requires an aggrieved client to put her or his allegations on the record, after which the judge must make a sufficient inquiry of the defendant and appointed counsel to determine whether or not there is reasonable cause to believe that court-appointed counsel is not rendering effective assistance to the defendant. Where reasonable cause for such a belief appears, substitute counsel must be appointed and allowed adequate time to prepare. And if no reasonable basis appears to find existing counsel ineffective, then new counsel won't be appointed, although the defendant is free to hire private counsel at any time. As an aside, where an aggrieved client chooses to discharge her or his court-appointed counsel and wants to proceed pro se, meaning without a lawyer, serving as her or his own lawyer, then the court must conduct a separate inquiry, which is known as a Feretta hearing. That said, I thank you for your question and I appreciate your having asked it. Please remember that at Haber, PA, it's all about reasonable doubt. And if you like this video, then please subscribe to our YouTube channel. We'll be putting out more soon.